Now, the Commission for Conciliation, Mediation and Arbitration has ruled in favor of a company that fired an employee for refusing to be vaccinated. The CCMA ruled that the sacking was substantively fair. To talk to us about this, we're joined by employment lawyer Lovanya Moodley. Lovanya, good evening and thank you very much for your time. Is this an indication that the CCMA would now deem vaccine mandates in the workplace a fair process to put in place?
Good evening, Thabo. That's a big question. Firstly, the point I would like to make is that this ruling does not have a precedent-setting effect. It's final and binding only onto the parties that were involved in this particular matter. And if I may go so far as to say, it's unlikely that this would be the last word on the matter. There's room potentially for the employee to take this ruling on review to the Labour Court. And because it raises certain constitutional considerations, it may even escalate all the way to the Constitutional Court.
So
I think it would be...
What could the CCMA could have looked at here, particularly to reach the conclusion that it is substantively fair?
In any dismissal case, the CCMA commissioner would have to consider whether the dismissal was substantively and procedurally fair. In terms of substance, we're looking at were the reasons that the employer considered in dismissing this employee reasons fair. Some of the considerations that would ordinarily be looked at is there was a rule in place, if the employee was aware of the rule, was the rule reasonable, was it consistently applied? In this particular case, there was a mandatory vaccine policy in place. The company followed the consolidated directive that deals with how to implement a mandatory vaccine policy. They followed the consultation process with all relevant stakeholders, including employees, trade unions, for a period of 3 months, circulated copies of this policy to employees, made them sign an acknowledgement of receipt, and the employees could make use of an exemption or an appeals procedure if they did not want to be vaccinated, and they could have raised constitutional concerns such as their bodily integrity, religious or medical grounds. This particular employee based her argument on bodily integrity and indicated that she would not be vaccinated. And then the employer considered that it needed to create a safe working environment for all its employees. And that was the reason, the substantive reason, that the commissioner accepted in this case to rule that the decision to dismiss her was fair.
Yeah. Is the requirement that the employer would need to maybe move that employee to maybe another position or to another station where they could work in a manner that would not bring harm to the other employees?
For incapacity due to the employee being considered permanently incapacitated in that she could no longer perform her duties because she refused to get vaccinated. Ordinarily, in incapacity matters, there's an obligation on the employer to reasonably accommodate the employee in alternative positions, or rather in the first instance, accommodate the employee in her current role before considering alternative positions that the employee could be accommodated in. In this matter, the ruling says that the company laid evidence that there was no suitable alternative position for this employee, and that's why she was eventually dismissed. What it's silent on is on any alternatives to an alternative position that the company considered. For example, permanently remote working, if that was a reasonably practicable solution.
Yeah. I mean, essentially what it says, if for example, my job would require that I interact with other people or other employees on an in-person basis, and I refuse to vaccinate, that could be deemed a dismissible situation.
That could be, but it's not as clear-cut as that. For example, if the employee raised religious grounds on which, and that wasn't the case in this matter, but theoretically, if you were to say that on religious grounds or medical grounds, and you were able to provide proof of these grounds that you are raising, then an alternative, then maybe the dismissal wouldn't be so appropriate in those circumstances. But in this particular circumstance, these were not the grounds that the employee raised. It was a pure refusal based on her bodily integrity. And unfortunately, in the ruling, there wasn't much of discussion on that point and why the limitation to that right was considered appropriate in this circumstance.
Yeah. Does that then indicate maybe if that particular matter is taken to a higher court, they might want to entertain that and could come to a different conclusion?
Possible that a court could come to a different conclusion, which is why I think it would be premature to say that this is a clear indication of the direction that companies in South Africa, or rather the CCMA, is taking in matters like this, because it's not the final word in the matter. And also, there's additional judgments or additional matters that are going to be heard in the coming weeks at our Labour Court and at High Court dealing with similar issues. Those judgments have precedent-setting effects, so I would watch out for those.
Yeah. And would those particular judgments have an impact on this particular case? Could this employee go back to the employer and maybe claim damages? Because maybe I could have been out of work for a whole 12 months while I'm waiting for all the other cases to go on. And it turns out you were actually not supposed to dismiss me to start with.
Is to take this award on review. It's available to any employee or company for that matter who receives an arbitration award that's not in their favor. The next step in the process would be to refer a dispute to the Labour Court for review. At that stage, if there are judgments that are persuasive in favor of the employee, that would need to be taken into consideration.
Lovanya, I appreciate your time and thank you very much for talking to us tonight. That's the employment lawyer there, Lovanya Moodley, outlining the details of this latest ruling by the CCMA.